Ready? Oh, hi there. Good morning. Before we begin, I'd like everyone to please take a minute to check their cell phones and make sure they're silenced. All right, this November meeting of the Punta Gorda Code Enforcement Board is called to order. Will the clerk please call the roll?
Good morning, Deputy City Clerk Jennifer Faulkner. For the record, we've got for attendance call today, Mr. Keith Johnson.
Here.
Jeffrey Fox. Carl Rich.
Yes.
Joe Como. Here. Kathleen Antona.
Present.
Robert Engelhart. Here. Ronald Mushong. Mark Hatala. And Adele Higgins.
Here.
I also wanted to briefly, before the meeting gets started, we were doing this at all of the November board meetings. City Council did issue a proclamation in recognition of Board Member Appreciation Month, and for those of you who either weren't at the council meeting or didn't hear the council meeting via live stream, just wanted to read that proclamation and express on behalf of the city and the clerk's office our appreciation for the board members. Whereas local governments provide the most access to decision-making processes that directly impact the daily lives of their citizens, and the City of Punta Gorda's residents actively participate in these decisions through attendance of meetings or provision of input, without which government cannot be of the people, by the people, and for the people. And whereas many dedicated citizens seek greater opportunities to influence their community today and in the future by serving on advisory boards. As board members, they have the opportunity to make decisions regarding the application of city codes, as well as provide advice to the City Council regarding legislative matters. And whereas the city currently has 11 boards with 71 seats for residents to fill in order to help shape the future of their community. These board members generously volunteer their time to fulfill the duties of each board, sharing their expertise and acting with integrity in their deliberations. And whereas board members report feeling more knowledgeable about municipal projects, more connected to their neighbors and city staff, and more fulfilled for contributing to a strong and diverse community through their service on the city's advisory boards. Now therefore, the City Council of the City of Punta Gorda, Florida, does hereby declare November 2024 to be Board Member Appreciation Month and urges citizens to volunteer for advisory boards, attend public meetings, and stay updated on city business by reviewing board agendas and notices posted to the city website. Passed and duly adopted the 6th day of November 2024, City of Punta Gorda. So thank you again so much for your service. We appreciate it.
Thank you. And while we're speaking about service, it is my understanding that Supervisor Lavosia Price will be leaving his position with the city. Officer Price, this will be, I guess, the last meeting that you'll be attending for the Code Enforcement Board. On behalf of the board, please stand up so everybody can see you. There we go. Thank you. Yay. On behalf of the board, thank you so much for your service. Thank you for what you've done to keep things moving for the City of Punta Gorda. We wish you every success in the future, and if you ever have nothing to do, you can certainly come and attend a meeting of the Code Enforcement Board. Thank you so much. All right. Has every board member had the opportunity to review the minutes of the prior meeting? All right, I'll entertain a motion with regard to the minutes.
I'll make a motion that the minutes for the September meeting be approved.
Second.
There's a motion and a second. Any discussion? All in favor signify by saying aye.
Aye. Aye.
Any
Aye.
opposition? The motion carries. The minutes for the September 25, 2024 meeting are approved. There will be no meeting for December, is that correct? And the next meeting is January 22nd, 2025, and I'm presuming it will be here at the Military Heritage Museum. All right, that will be our next meeting. All right, will the clerk please swear in the witnesses?
Anyone who is intending to give testimony before the Code Enforcement Board, please stand and raise your right hand. And I apologize, I do not have the actual verbiage in front of me. It's been a minute since I've done this, so if I say anything that, if I make you swear to something I'm not supposed to, I'm sure the city attorney will let me know. Essentially, please just state that you agree to tell the truth and the whole truth regarding the proceedings today. Yes. And when you do come to the podium to speak, please make sure that you state your name and indicate that you have been sworn for the record. That'll do. Thank you.
All right, is there anything else before we proceed with the agenda? All right. All right, the first matter then is hearing in the contest of citation number 205764. 24-86899, Police Officer Justin Cleaver, Respondent Lawrence Seaman, address of violation 2700 Luna Court, violation of Chapter 26, Section 3.13J, overnight parking.
Hello there, Corporal Justin Clyber, have been sworn in.
Turn your mic on.
Hit the microphone.
Corporal Justin Clyber, I have been sworn in.
I apologize for mispronouncing your name.
Not a problem.
Officer, would you indicate what you observed on the night that you issued the citation?
Before we go, I just want to make sure, is the respondent present? Mr. Seaman, are you present? Yes. Thank you, Mr. Seaman. Go for it.
Would you tell the board what you observed on the day of the violation?
On September 15th, around 1:30 a.m., I was conducting patrol in Punta Gorda Isles. Along Hibiscus Drive, in front of 84 Hibiscus Drive, I observed a red Dodge pickup truck bearing Florida license plate Y922PB parked in a roadway. It was between 1 a.m. and 5 a.m., so I issued a citation for that vehicle for the violation of being in the roadway between 1 a.m. and 5 a.m.
And was that location within the territorial bounds of the city of Punta Gorda, Florida?
Yes, it was.
And did you make contact with the occupant of the car?
There was nobody in the car. It was parked and unoccupied.
Anything else you'd like to say about this violation?
Nope.
Thank you.
Mr. Seaman?
Good morning. My name is Lawrence Seaman, and I've been sworn in today.
Okay, do you plead guilty or not guilty to this?
Not guilty.
All right. Go ahead. What would you like to say?
Yes, good morning, everyone.
Good morning.
Thank you for this opportunity. I come before you as I received a parking violation on that specific date at nighttime. I had circumstances beyond my control where I could not take the car off the street that evening. I parked the car there, the truck, there about 8 o'clock at night, 8:30, and it started to rain, and we had one of those summertime lightning and thunderstorms that were persistent for several hours, and it was unsafe to go outside to move the car back to my home where I live across the street on Hibiscus Drive for the last 12 years. And I please ask for your forgiveness that because of the fact of the weather, it prevented me from going outside late at night and returning my car back to my garage. And I woke up the next morning early at 5:30 to remove the truck from the street before anyone woke up, as I am a prudent, safe neighbor in Punta Gorda, and I respect my neighbor's property and the city's property as well. So I ask for your forgiveness on this specific one time where I have no history of ever violating any crimes of the city, and I am a registered nurse for 45 years, and I have a very safe driver's record, and I ask that this be pardoned, please.
All right, thank you.
Officer, at the time that you issued the citation, did you see any evidence of either rain at the time or previous rain?
The vehicle was wet from previous rain. At the time of the violation, it was not storming, but it had been raining earlier in the evening.
Thank you.
All right, does any board member have any questions for Officer Cliver or for Mr. Seaman? Officer, you issued the citation because you were on patrol. You did not receive a complaint from anyone in the neighborhood. Is that correct?
Correct, I was on patrol.
And Officer, Mr. Seaman has indicated that he's never had an issue in that neighborhood or been cited before. Can you corroborate that as far as you know?
Without having my computer and running the plate to see if we had any prior history, I would not be able to advise at the moment.
But you've never seen it as you've been patrolling that you remember?
Not that I can recall, but been here for some years, so could have gone by it before, I'm not sure.
Okay, thank you.
Mr. Seaman, I guess I'm not clear. Why didn't you park the vehicle off the street to begin with?
I was actively working on another vehicle in my driveway.
Officer Cliver or perhaps the city attorney, normally how much of it is a citation in this case? Do you know what the cost of a citation is?
$25.
Okay, thank you.
All right, and there are no points that go on a driver's license for a parking violation, correct, Officer Cliver?
Correct, because it's a city ordinance.
Right, okay.
And excuse me, I'd like to add one thing, if I didn't say it already, that I have a safe driver's record, and my physical driver's license says that with renewals, multiple renewals, have been a safe driver all this time, and I've never had a violation of any sort. And being a registered nurse, I keep that as safe as possible, and I am very prudent for driving and being a neighbor in the city of Punta Gorda for the last 12 years.
Okay. Mr. Seaman, the vehicle was parked across the street from your house, is that correct?
Yes, ma'am, on a side street.
Around the corner type?
Yes, ma'am, it's one of the side streets in Punta Gorda that has a limited amount of homes, and I thought that would be a safe place to park the vehicle while I was working on my other vehicle that evening, and that street only has about 8 or 10 houses on it versus a long street like Hibiscus Drive that has more traffic. So I thought that would be safe and out of the way of neighbors driving back and forth home.
Okay, thank you. I'll entertain a motion as to whether we can call for a vote.
I'll make a motion. I'd like to make a motion that citation 205764 is valid, and the respondent did violate Chapter 26, Section 3.13J of the Punta Gorda Code, order a fine in the amount of $25 plus case costs incurred in the amount of $19.73, and payment must be made immediately upon receipt of the order.
Is there a second?
Maybe we, $19.73 in court costs.
Is what, court costs?
Court costs.
Isn't that what I said?
Where do we see that?
Let me clarify, so the fine is 25 plus 19 and change?
Yes.
Great, thank you.
Do we need to do a prima facie case on this?
No.
No, okay.
We don't need to find a prima facie case because this is a citation, correct?
Correct.
All right, is there a second to the motion?
I'll second the motion. I'll second the motion.
Any discussion? Well, I would like to suggest that in light of the fact that this seems to be a first offense and there seems to be some mitigating circumstances, although not circumstances that accuse the violation, that the amount of the fine be reduced to $10 plus case costs incurred in the amount of $19.73.
Yeah, I'm okay with that.
I'll agree with that also.
All right, so Mr. Who made the motion, Mr. Rich?
Yes.
Can we amend the motion then to make it $10?
Yes.
Is there a second?
I'll second that.
Any discussion? All in
Yes, I'd like to discuss.
Well, Mr. Seaman, this is a matter for the board right now. Your testimony is completed unless
Thank you.
Any further discussion?
I do have a question. As the newest member and least experienced, if the fine were waived, may we charge just the court costs?
We can, you mean adjudicate guilty and just say no fine, just court costs?
Yes, that's the question.
My understanding would be that's authorized. Is that correct, Mr. Levin? Or, excuse me, Mr. Lewis?
I'm reviewing the code right now. From my experience here, it's always whatever the minimum, you have to do it at the minimum fine, which would be $25.
You have to do it at the minimum fine? Does it say minimum fine or maximum fine?
Well, the fine itself is $25. And then if it's contested, it's up to $100 plus court costs.
And I wasn't interested in going up.
Okay, all right. Is there any provision that allows us to suspend the fine?
I'm reviewing the code right now, but I've never seen one that could, since this is a citation,
Right?
I've never seen that allows you to suspend fines.
Okay.
I understand that there's circumstances, but the officer wrote a legitimate
You did.
ticket, citation, and the individual did violate the city code. So I'm not interested in raising the fine up to $100 and punish, but
All right, well, unfortunately, Mr. Seaman, if the code requires a minimum of $25 for the fine, then upon adjudication, that's what we have to impose. Mr. Lewis, are you with me on that?
Dan?
Again, Daniel P. Lewis, Board Attorney. I'm just reviewing the city code to confirm
Okay,
that's the case.
okay. Would you like some time? We can,
Yes, I'm looking at it right now.
okay, let's
Madam Chair?
recess for a minute. Mr. Camo.
Just another point. We have found that this is a valid, that this actually occurred.
Correct.
I think that, as a board and as a representative of the city, there's an element of supporting our officer in this and not saying you made a mistake, and if we just sort of roll it back, I think that it may send the wrong kind of signal, albeit a small one, but I still think that we owe something to the officer, to the police force for doing their job. He went out, as Mr. Rich said, he enforced the code, he did what he was supposed to do, and we should support him in that as long as there's no other problems, and it doesn't appear as though there's any, extensive mitigating circumstances involved with this.
Okay, thank you. go off the record until Mr. Lewis is finished. Record.
Yes, minimum for a first-time fine is $25,
Okay, and, all right,
plus the additional court costs.
plus, okay. So unfortunately, Mr. Seaman, the minimum that we can fine you is $25, plus the court costs of $19.73. So I will withdraw my suggestion, and we're back to the original motion, which is a fine of $25 plus case court costs of $19.73, and payment be made immediately. Is there any second to the motion?
I'll second that motion.
All right, any further discussion? All in favor, signify by saying aye.
Aye.
Any opposition? The motion carries. Mr. Seaman, I'm sorry to inform you that you have been adjudicated to have been guilty of this offense. Please see the court clerk, if you'll raise your hand, for details on how to pay your fine. Thank you. Thank you for coming today. We do appreciate it. All right, the next matter is a hearing in case number 24-86129. Code Compliance Officer Nick Faulkner, Respondent Joan Sawaski, address of violation 1580 San Marino Court, violation alleged Chapter 26, Section 8.11A, dirty roof, and Chapter 9, Section 9-28, tall grass and/or weeds. Is the respondent present? Is the respondent present? All right, the respondent not being present, I will enter a plea of not guilty on her behalf. Mr. Faulkner.
For the record, Nick Faulkner, Code Compliance Officer for the City of Punta Gorda, and I have been sworn. According to the Charlotte County Property Appraiser's records, the property located at 1580 San Marino Court is within the city limits of the City of Punta Gorda, Florida, and the property is owned by the respondent. I'm submitting 13 photos for the record. The pictures submitted for evidence are a true and accurate representation of the condition of the site at the time the pictures were taken. On July 9th, 2024, I inspected the property and found that more than 20% of the roof on the house structure is not maintained as to be free from dirt and mold, which is a violation of the Punta Gorda Code, Chapter 26, Section 8.11A. and tall grass and/or weeds exceeding 12 inches in height throughout the property, which is a violation of the Punta Gorda Code, Chapter 9, Section 9-2H. On July 10th, 2024, a notice of violation or order corrective action was sent to the respondent via certified return receipt mail, ordering corrective action to be taken and the roof on the house structure be cleaned, maintained within 30 days of receipt of the notice, and the tall grass and/or weeds be mowed, trimmed, and maintained within 5 days of receipt of the notice. On July 15th, 2024, the notice of violation or order corrective action was received by the respondent via certified mail. On September 19th, 2024, I re-inspected the property and found that the tall grass and/or weeds throughout the property had been mowed, trimmed, and maintained. However, the violation had not been corrected, and that 20% of the roof on the house structure was not maintained as to be free from dirt and mold. On September 23rd, 2024, a notice of hearing was sent to the respondent via certified return receipt mail. On October 16th, 2024, I posted said notice of hearing on the property and at City Hall Annex. On October 21st, 2024, the notice of hearing was returned undelivered to the respondent. On October 16th, 2024, a notice of continuance to the November 27th, 2024 Code Enforcement Board meeting was sent to the respondent via certified return receipt mail, which was delivered on October 31st, 2024. On October 16th, 2024, I posted said notice of continuance on the property and at City Hall Annex. On November 26th, 2024, I re-inspected the property and found that the violations had not been corrected and that more than 20% of the roof on the house structure was not maintained as to be free from dirt and mold. I'm submitting an invoice for case costs incurred in the amount of $41.08.
Mr. Faulkner, can you describe what you see on the roof for the record?
Dirt and mold.
And what is your estimate of the percentage of the roof that is affected by dirt and mold?
Near total, so 95 to 99, 100%.
All right. And so, and from your description and from the charge, it's not that the roof is in disrepair, it's just that it's dirty.
Correct.
Correct? Is there anyone living in the property?
Not that I'm aware of. I don't know.
Not that you're aware of? All right. Any other questions?
This is going to sound like a silly question, but
No. I already asked.
this is going to sound like a silly question, but I'm going to ask it anyway. How do you know the roof is dirty and that's not the color of the tile?
Because you can see certain spots of the roof that is actually what the color is supposed to be. If you hang on a second, I can find the picture right here. Let me find it.
This being a picture dated July 9.
Yes, if you see right on the right corner, the gray on the roof,
Yes.
that's what color it's supposed to be. And as you can see, to the left, it is covered with the black dirt and mold.
And you also indicated, I believe, that the most recent notification of this meeting was delivered? I think you said that.
Yeah, the most, October 21st, the notice of hearing was returned undelivered, but it was also posted on their property on the 16th of October, 2024. But the continuance to this meeting was received.
Okay, thank you.
Was the continuance to this meeting received by certified mail?
Yes.
No. I'll entertain a motion regarding a prima
I
facie
have
case.
a question first, kind of bookkeeping here. On this, we are saying it's a violation of Chapter 26, Section 8.11A, and in the materials that we received, it mentions Chapter 26, Section 8.11B. There is no definition of the property maintenance and roof of the A part of it.
affidavit of violations has A, dirty read.
Lavoisier Price Code Supervisor, I have been sworn. Which pamphlet are you talking about? Is Mr.
Okay.
That? Okay, yeah. I might have accidentally deleted that from it. But it basically states that a roof has to be maintained not to have more than 20% dirt or mold on it. Yeah, so I probably deleted it on accident when I was going through them.
I just wanted to
That's
make
all
sure-
it is. It's just for your information.
I just
so
want
that
to
you
make
know
sure
what-
that we
what
are
the code is.
actually having the violation as the correct.
Yeah, so that's
Yes.
an oversight on my spot, but
Okay.
that is the correct code.
Yeah, the
that is
affidavit of
being
violation
used.
says 8.11A, and that's correct, Mr. Officer Price?
Yeah, that's the correct code. being
Yeah,
used.
okay. All right,
And just further, my mind of clarification also, the tall grass and or weeds has been disposed of, that's fine.
Correct, that they're in compliance on that part.
Thank you.
Make a motion that the city has established a prima facie case.
is there a second?
Second.
Any discussion? All in favor signify by saying aye.
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 Any opposition? The motion carries. The city has established a prima facie case. Is there any other questioning for Officer Faulkner? And the respondent is not present. I'll entertain a motion regarding a violation.
All right, I'll make the motion.
Okay.
I make a motion to find that the respondent violated Chapter 26, Section 8.11A of the Punta Gorda Code and issue a cease and desist order for any future violation of the Punta Gorda Code, Chapter 26, Section 8.11A, and order that the respondent bring the property into compliance within 30 days, receipt of this order, and further order that the respondent is required to pay case cost and incurred in the amount of $41.08 within 15 days of receipt of this order. Further ordered that failure to comply with the order may cause Code Enforcement Board to impose a fine of up to $250 per day, plus applicable cost. Interest, sorry.
Okay, there's a motion. Is there a second?
Second.
Any discussion?
Yeah, I just have one thought. If this is a roof that's going to be replaced because of storm damage, would we still expect these individuals to clean the roof that they're getting ready to replace?
Well, the first visit was in July, which was before the storms.
Okay, my question, I'm done, thanks.
Okay, but I do have a question for Officer Faulkner. I am presuming, if you know, that a power washing of the roof will take care of this. This is not a major thing where they would have to deal with a contractor and get everything in order.
Cleaning of the roof does not require a permit, but they can either pressure wash or there's a wet and forget. Also, that's an option, so they have multiple options on getting this roof cleaned.
And
Okay,
they
but it's
haven't-
not something that realistically would take more than 30 days to get done.
Correct.
Okay. Mr. Kumar.
This is the first one of these we've seen in a while. We used to see a lot more of these before the state put in a provision regarding anonymous complaints. And there were a lot of scams going on where power washers would, hey, would you like your roof washed? And then they would call in and there'd be a complaint. That thankfully has been taken care of. The big problem they may have is finding a power washer right now. But I mean, you see weird things where one of my neighbors, he cleaned the front of his house, the back of his house that you could only see across the canal. He cleaned just the edges so that you could kind of see, and then just left mold all over the rest of things. It's amazing the extent that people will do to kind of work around this particular violation. And I'm glad to see that it has returned to enforcement.
All right. Mr. Levin, do you have anything you want to add?
So this is, of course, a visual blight type of a case and code violation. So it's intended to take into consideration the impacts to the neighbors. Had the respondent been present and provided testimony that would suggest that, well, because of the condition of the roof, by pressure washing it, may cause leakage and damage, maybe that would be an extenuating circumstance that you could find some sort of deviation from requiring the cleaning of the roof. But that did not take place. And so I would request that you do not take into consideration speculative evidence and require that the roof be treated for the benefit of the neighborhood.
Well, I don't think that's in the discussion. The purpose of my question was just to make sure that 30 days was in a reasonable period of time, that it was not something that required to get a contractor and a permit and all that kind of stuff.
Yeah, I'm just saying that, we had the discussion at staff that there had been some suggestion that the reason why it hadn't been taken care of is because the roof is going to be replaced anyway. Well, the roof is staying in its present condition for a while, and as I said, it's a problem for the neighborhood. And had there been testimony that there was an issue with the roof that might have excused the power washing, then that would be something that would be of relevant consideration by you. But we're asking that you disregard the speculation that it's being repaired or removed or replaced, and that should excuse the cleaning of it.
Yeah, and you're correct. The respondent isn't here to provide any explanation, so we have to take what we have.
Thank you.
Mr. Levinan, for the board, isn't it reasonable to expect that if that were the case, that the respondent would have notified us?
Well, yes, we would expect that the respondent
Yeah.
be here, or an agent for the respondent be here to testify as to why you shouldn't find them in violation.
And the respondent has not done that?
That's correct.
Okay, thank you.
All right. Okay, there's a motion that's been made and seconded. Is there any further discussion? All right. All in favor signify by saying aye.
Aye.
Any opposition? The motion carries. The board has found that the respondent violated Chapter 26, Section 8.11A of the Punta Gorda Code and has issued a cease and desist order for any future violation of the Punta Gorda Code, and has ordered that the respondent bring the property into compliance within 30 days of receipt of the order, and it's further ordered that the respondent be required to pay case costs incurred in the amount of $41.08 within 15 days of receipt of the order, and further ordered that failure to comply with the order may cause the Code Enforcement Board to impose a fine of up to $250 per day, plus interest, applicable interest. Thank you.
Thank you.
Thank you. All right, the next case is a hearing in case number 24-86289, Code Compliance Officer Meredith Achtenberg, Respondent Paul Perry Lynn, address of violation 431 Henry Street, violation of Chapter 9, Section 9-2H, tall grass and/or weeds, violation of Chapter 26, Section 8.11B, property maintenance structure. I understand there is a motion from the city.
A motion to dismiss. The property is under new ownership.
As the property in compliance? No. All right. Officer Price?
Code Compliance Supervisor Laborte Price Jr. So since the property is under new ownership, which we found out, I believe Monday, we have to cite the new owner.
Okay, so it's a motion to dismiss this case, and you're going to start a new case.
Yep.
All right. All right. All right, before us, there's a motion from the city to dismiss this. Is there any discussion? I'd like a member of the board to make a motion to accept the city, whether to accept the city's proffer.
I'll make a motion to accept the city's proffer to dismiss.
All right, is there a second?
Second.
All in favor, say, any discussion? All in favor signify by saying aye.
Aye.
Any opposition? The motion carries. This matter is dismissed. And based on your statement, Officer Ochtenberg, I'm assuming the city will initiate action against the new owners. All right, thank you. Good catch, by the way. All right, the next matter is a hearing in case number 24-86331, Code Compliance Officer Meredith Ochtenberg, Respondents Robert E. and Lisa E. Johnson. Address of violation 322 East Grace Street. Violation of Chapter 26, Section 8.11B, Property Maintenance Structure, and Chapter 9, Section 9-2A, Outside Storage. Are the respondents present? Are the respondents present? All right, the respondents not being present, I will enter a plea of not guilty on behalf of the respondents. All right, Officer Ochtenberg, good morning.
For the record, Meredith Ochtenberg, Co-Compliance Officer for the City of Punta Gorda, and I have been sworn. According to the Charlotte County Property Appraiser's records, the property located at 322 East Grace Street is within the city limits of the City of Punta Gorda, Florida, and the property is owned by the respondent. I am submitting 22 photos for the record. The pictures submitted for evidence are a true and accurate representation of the condition of the site at the time the pictures were taken. On July 3rd, 2024, I inspected the property and found the siding and the roof on the house structure in disrepair, which is a violation of the Punta Gorda Code, Chapter 26, Section 8.11B, and outside storage on the property, including but not limited to cement blocks and other miscellaneous items, which is a violation of the Punta Gorda Code, Chapter 9, Section 9-2A. On July 3rd, 2024, a notice of violation and order for corrective action was sent to the respondents via certified mail, ordering corrective action be taken and the siding and roof on the house structure be repaired and building permits be applied for and obtained within 30 days of receipt of the notice, and the cement blocks and other miscellaneous items be properly removed from the property within 5 days of receipt of the notice. On July 9th, 2024, the notice of violation and order for corrective action had not been received or returned undelivered. On August 8th, 2024, I posted said notice of violation and order for corrective action on the property and at the City Hall Annex. On September 11th, 2024, I re-inspected the property and found that the violations had not been corrected and that the roof and siding remained in a state of disrepair, and the cement blocks and other miscellaneous items remained on the property. On September 11th, 2024, a notice of hearing was sent to the respondents via certified return receipt mail. On September 11th, 2024, I posted said notice of hearing on the property and at the City Hall Annex. On September 13th, 2024, the notice of hearing was received by the respondents. On October 15th, 2024, a notice of continuance to the November 27th, 2024 Code Enforcement Board meeting was sent to the respondents. On October 15th, 2024, I posted said notice of continuance on the property and at the City Hall Annex. On October 17th, 2024, said notice of continuance was received by the respondents. On November 26th, 2024, I re-inspected the property and found that the violations had not been corrected and that the roof and siding remained in a state of disrepair, and the outside storage on the property, including but not limited to cement blocks and other miscellaneous items, remained on the property. I am submitting an invoice for case costs incurred in the amount of $48.08.
Any questions? I'm a little confused as to the citation regarding outside storage. Can you show me a photo that shows the outside storage that you're talking about?
Right there, actually. It's that cement block.
Oh, that's not permanent?
And right there also. There's cement blocks.
Oh, in the
Yes.
yard, there's cement blocks?
Yes.
But that large
Yeah,
block, is
pink.
that a permanent structure?
I don't believe so.
No.
Make a motion, the city establish a prima facie case.
Is there a second?
Second.
All right, any discussion? All in favor signify by saying aye.
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 Any opposition? All right, the city has, a motion has been made and seconded and carried that the city has established a prima facie case. Are there any more questions for Officer Ochtenberg? The notices that were mailed and received, they were mailed to this address?
They're looking.
They're looking. There's no one.
They were not at that address, though.
No, there's no one residing here.
No.
Sure they'll look like.
On Pinewood Lane in Punta Gorda.
Okay. All right. Is there any further discussion before a motion?
I did have contact with the property owner yesterday.
Okay.
She contacted me, and a demolition permit has been applied for. It has not been approved yet, though.
A demolition permit for the entire structure?
Correct.
All right. What's the turnaround time for such permits?
I'm sorry?
What is the normal turnaround time for such permits?
I'm unsure. That would be a building department.
Okay, but that's a city issue, correct? The city issues the permits.
That's correct.
Okay. All right, is there a motion?
I'd like to make a motion to find that the respondents violated Chapter 26, Section 8.11 Bravo of the Punta Gorda Code, and Chapter 9, Section 9-2 Alpha, issue a cease and desist order for any future violations of Chapter 26, 8.11 Bravo, and Chapter 9, 9-2 Alpha of the Punta Gorda Code. Ordered the respondent bring the property into compliance within 90 days of receipt of this order. It is further ordered the respondents are required to pay case costs in the amount of $48.08 within 30 days of receipt of the order. And is further ordered the failure to comply with this order may cause the Code Enforcement Board to impose a fine of up to $250 per day plus applicable interest.
Is there a second?
I'll second that.
All right, any discussion?
I gave 90 days because if they're going to demolish the whole thing, that's a bigger task than just a permit to re-roof or something, so.
Yeah, that was going to be my question. Thank you for putting that on the record. All right, motion has been made and seconded. Any further discussion? All in favor signify by saying aye.
Aye.
Any opposition? All right, the motion carries. The board has found that the respondents violated Chapter 26, Section 8.11B of the Punta Gorda Code and Chapter 9, Section 9-2 Alpha of the Code, and issue a cease and desist order for any future violations of these code sections, and order that the respondents bring the property into compliance within 90 days of receipt of the order. And it's further ordered that the respondents are required to pay case costs incurred in the amount of $48.08 within 30 days of receipt of the order, and further ordered that failure to comply with the order may cause the Code Enforcement Board to impose a fine of up to $250 per day plus applicable interest. Thank you. All right, the next item is hearing in case number 24-86648, Code Compliance Officer Nick Faulkner, respondents Robert M. and Jennifer G. Bear, address of violation 1601 Via Bianca, violations alleged Chapter 9, Section 9-2H, tall grass and/or weeds, and Chapter 9, Section 9-2A, outside storage. Are the respondents present? Are the respondents present? All right, the respondents not being present, I will enter a plea of not guilty on their behalf. Mr. Lewis.
Yes, thank you. Again, Daniel P. Lewis, Board Attorney. Just for the Board's awareness, there will likely be citizen testimony in this matter, and I want to take this time just to remind the Board, when we have code enforcement cases, this is a quasi-judicial hearing. We have our three tenets, which are due process, observe the requirements of law, and rulings based on competent substantial evidence. The most important thing to remember, especially with due process, is there's fairly strong body of case law and Attorney General's opinions that when we have citizen, resident, witnesses, not who are, say, city employees or code enforcement officers, that we always have to be careful about what their testimony is and what the questioning is, because what can happen is it can veer off into less competent substantial evidence, which is based on fact, based on what, and become what's called essentially the animus of the community. If there's an issue of we don't like the people or we don't like the situation, it can become, as is stated in the case law, ruling based on a mob rule. And we want to avoid that because that could become a due process violation, because you do have the authority to impose sanctions upon people for code enforcement violations. And what that does is, instead of making a ruling based on the evidence of what you've seen before you here today, it becomes on, it has the potential to become let's make a ruling against a person because we don't like them. And I only bring that up because our testimony and questioning have to veer into, be pinpoint and be dedicated to the facts of the case and what the citations are here for today. The city can call witnesses, can call citizens, and that's the proper avenue for it. But I just wanted, and I will chime in if I'm worried it's kind of veering away from like actual case law, the actual case, and more into, again, public animus, as it's called. I may just step in just so that just kind of get it back on the tracks, because that's a very easy way to appeal a case and bring it back to you if it goes off into just anger of a circumstance.
But just enlighten us, there is not a prohibition against citizen testimony, is there?
Citizen testimony called by witnesses, that's fine. Public comment, we can't have just a public comment, but if the city calls witnesses, that's fine.
Okay, and so these citizens who are going to testify are going to be called by the
I
city?
believe I'll let Mr. Levin.
So, yes, we do intend to call some citizens, but I think the purpose of the previous discussion was that there are two violations that are before you today. That's the tall grass and weeds and outside storage. There may be other concerns that the citizens have, but they are not relevant to you today because there's only the two violations that you're going to hear. So I'm going to ask the witnesses to confine their comments to those two cases, violation that are before you. And if there's any other future violations that we can substantiate, then we'll certainly make cases at that time. But
All right, and I am presuming that since the respondents received notice of this hearing, that encompasses the possibility that there may be other testimony.
well, there's certainly going to be testimony.
Right.
The respondent doesn't necessarily need to know who's going to testify. But again, the due process concern is that since the respondent is brought before you on the two specific violations that have been noticed, it would be a violation of due process to bring in other testimony that's not related to that, particularly if we are going to make another case going forward on other violations that you may hear today without any opportunity for the respondent to rebut. So
Okay,
that's
so we
why it's
will be
important.
careful then, and I appreciate the elucidation. We will be careful then to confine ourselves to the code sections that are charged in this
Thank you very
in
much.
this
That's
complaint.
what we're asking for.
All right, thank you. All right, Officer Faulkner.
For the record, Nick Faulkner, Code Compliance Officer for the City of Punta Gorda, and I have been sworn. According to the Charlotte County Property Appraiser's records, the property located at 1601 Via Bianca is within the city limits of the City of Punta Gorda, Florida, and the property is owned by the respondents. I'm submitting 29 photos for the record. The pictures submitted for evidence are in true and accurate representation of the condition of the site at the time the pictures were taken. On August 22nd, 2024, I inspected the property and found tall grass and/or weeds exceeding 12 inches in height throughout the property, which is a violation of the Punta Gorda Code, Chapter 9, Section 9-2H. On August 23rd, 2024, a notice of violation order corrective action was sent to the respondents via certified return receipt mail, ordering corrective action be taken and the tall grass and/or weeds exceeding 12 inches in height be mowed, trimmed, and maintained within 5 days of receipt of the notice. On August 26, 2024, the notice of violation order corrective action was received by the respondents. On September 10, 2024, I re-inspected the property and found that the violations had not been corrected and that the tall grass and/or weeds exceeding 12 inches in height remained throughout the property. There was also outside storage on the left side of the house structure on the property, including but not limited to mechanical equipment, a wheel, and other miscellaneous items, which is a violation of the Punta Gorda Code, Chapter 9, Section 9-2A, and a vehicle being parked in or stored on the rear yard of the property, which is a violation of the Punta Gorda Code, Chapter 26, Section 3.13I. On September 29, 2024, an amended notice of violation and order corrective action was sent to the respondents, ordering corrective action be taken, and the tall grass and or weeds exceeding 12 inches in height be mowed, trimmed, and maintained within 5 days of receipt of the notice, and the outside storage be removed or stored inside an enclosed garage within 5 days of receipt of the notice, and the vehicle be removed from the rear yard of the property within 24 hours of receipt of the notice. On September 21st, 2024, the amended notice of violation or order corrective action was received by the respondents. On October 16th, 2024, a reinspection of the property found that the vehicle had been removed from the rear of the property. However, the violations had not been corrected and that the tall grass and or weeds exceeding 12 inches in height remained throughout the property, and the outside storage on the left side of the house structure and on the driveway remain on the property. On October 18th, 2024, a notice of hearing was sent to the respondents via certified return receipt mail. On October 21st, 2024, the notice of hearing was received by the respondents. On November 26th, 2024, a re-inspected the property and found that the violations had not been corrected and that the tall grass and or weeds exceeding 12 inches in height remain on the rear yard of the property, and the outside storage on the left side of the house structure, on the driveway, and on the rear of the property, including but not limited to an interior door, wooden pallets, mechanical equipment, paint cans, couches, plywood, a metal ladder, landscape debris, and other miscellaneous items remain on the property. I'm submitting an invoice for case cost incurred in the amount of $22.07.
Any questions from the board? Mr. Faulkner, did I see a for sale sign on one of these pictures?
On the vehicle, yes.
Oh, it was on the vehicle?
Yes.
Oh, okay.
I thought it was on the house,
I thought it was on the
in
house.
front of the house.
There's a for sale sign there on the vehicle.
It was it was over, with the sign regarding Sheriff Prummel.
Yeah, by the front door.
All right, no, it doesn't matter.
Right there.
Right there, yeah. There
Oh,
it
yeah.
is. See it? What was the date on that? Back up. Right there, 8/22?
August.
8/22. Okay. All right. Okay, any questions from the board for Officer Faulkner?
Okay.
All right, do you have any other witness testimony?
Yes, if anyone would like to enter testimony, you can do so now. And then just state your name and indicate that you've been sworn.
Morning. Joe Sander, 705 Pamela Drive.
Is your microphone on?
Joe Sander?
It's a, there you go.
I usually don't need a microphone, but
It's recorded.
Joe Sander, 705 Pamela Drive. I can assure you, number one, this is not a personal situation. We're 18 months in Punta Gorda Isles, and spent a significant amount of money to live here, spend our time here, enjoy the community. But it's hard when your residence overlooks what you all see right here. And I will just share that what you see in terms of grass being cut in the back, I look at his backyard, my wife and I, along with Mary. That backyard is actually cut, what you see here. Okay, and he just did it just this week prior to the hearing. I was wondering why he did it. And I will just share that it's limiting wanting to be in this community, to have the community accept and city officials accept this, which there's many homes in the community that are for sale, and I would think that everybody has an interest in this room for home values to be kept up. And in the short time that we've been here, this has just been an ongoing situation. And I guess what I'm interested in here is not the $22 fine and not the next step in terms of when he has to clean the junkyard, because it's literally a junkyard. Okay, you can call it what you want. But what is the step after that? What is the next step when it happens again? Because this gentleman's been living here, my understanding, for 15 plus years. This is not the first circumstance of a situation. Yes, the most recent, I understand, in August, et cetera, the dates that were used. But why allow this to continue? And what are the next steps of responsibility for that owner and for this council to make so this does not occur on an ongoing basis? That backyard, he also uses as a racetrack with his vehicle when he's not pulling it around and then just throwing everything out on the lawn, meaning when I say everything, he picks up the gentleman, and I don't know, this is not personal. I said hi to him the other day. I go fishing by his thing.
Sir, I'm sorry, but we've gone into
okay.
what I'm discussing.
What I want to say here is that he uses the backyard as a race yard, as a racetrack.
And sir, I understand. And again, just to protect the record, this is about the outdoor storage and the.
Well, so I will just say that I'm most interested in when he violates again. What is the steps of this council?
Sir, I think we just have to cut it off at this point.
Good morning. My name is Tom Desenfonts. I live at 715 Brenda Court. The majority of these photographs that you're looking at across the canal were taken from my backyard. Nick has been there several times to take the photographs across the street. As the other gentleman said, this has been an ongoing affair. We lived across there for 18 years. It's been a real ride. This has been the worst that we've seen. But again, I'm interested in the property being corrected and continue to be corrected. I applaud your efforts and your service to help protect our property rights. Nick works hard for this. We appreciate all that. I have a question for you, and I've discussed this with Nick. There's an auto parked in this gentleman's front yard that's inoperable. It was towed there on the 17th of September. It has not moved. It does not have a license plate. Nick tells me that it's hard to ask.
Sir, I'm sorry, but again, we're going off into beyond what our violations are.
Sorry. I'd like to know how that can be addressed. Is that a fair question at this hearing?
You can't. It says this is a quasi-judicial hearing. You can't ask the board questions.
If I might, and Mr. Lewis, please correct me if I'm wrong. Sir, you can talk about that matter not in this public forum, but with the city staff, and they can.
All right, thank you.
They can talk about what the options are.
Okay.
Is that correct, Mr. Lewis?
Anyway, thank you for your service. I hope we can get this reconciled to our satisfaction, because it is undermining our property values. As the gentleman said, it's a terrible situation. You wouldn't want to live across the street from that guy any more than I do currently right now. Thank you.
But yes, if there are potential future violations,
New issues, then they can
please
talk.
bring them to the code enforcement officers so that they can be investigated and brought to this forum. That is the correct path, is to bring them to the code enforcement officers.
Okay.
Catherine Desenfant, 715 Brenda Court, wife of Tom, who just spoke. I'd like to see all of this corrected because, as you know, we're sick of it. Secondly, the car violation, the parked car, Nick said that's been taken care of. If he could be there every day, that violation occurs every day. You can't get a code compliance officer out there every time he parks in the backyard.
My name is Brenda Ray Coor, and I'm at 1604 Via Bianca, which is 2 doors away from the residence that we're talking about. Nick, can you explain to me what your job is?
I'm sorry, ma'am, but again,
Yeah.
Mr. Faulkner is a code enforcement officer. This is not a question-answer session. This is not public comment. This is a quasi-judicial hearing where the board is to hear testimony as to these two
Okay, then to the
charges.
board, I would like to say, I don't know what your code compliance people do, and when we can't get a hold of them, when things are happening, like the many photos you're seeing here, that we see every day, and the other things that are happening, who do we call? Because this is an ongoing thing. There's many, many things that
Thank you,
that are-
thank you, ma'am, but
All
again,
right,
we
okay,
need to get
let's-
testimony.
Let's, wait, okay. The code compliance staff works for the city. Who is the head of code compliance? Officer Price.
That would be me, Lavoisier Price, Code Compliance Supervisor.
And do you have a card, Mr. Price, with you?
Not on me, but
Are-
I believe most of them have my
In
information.
January. We're still in November.
I believe they still have my info. Some of them have. I spoke to. you
I've spoke
before.
with both of you, yes.
Tom before. Well, I think I spoke to Tom before also.
All right, and I am assuming, this is probably not the place to say this, but I am assuming that there are other potential code violation actions in the works in this against this property.
Currently, no. To be
Currently, no.
honest, no. So, as you see, the vehicle was cited in one of the notice of violations. Once that violation was corrected, it was removed from the next notice that was sent. Legally, we're doing everything that we can. We always do everything that we can legally. Some even say we go a little too far in our research sometimes.
All right, so if, let's just say hypothetically, this vehicle that we're talking about was removed from the property, and so it became no longer a violation, and my understanding is that there may be it may have returned to the property. And the neighbors are concerned about continuing violations or new violations.
Yes, so we would have to be able to prove those accusations.
Right,
We
and you have to
we are
start-
like
and
police
you have to
officers.
start a complaint.
We have to go by the facts. We can't go by assumptions or anything or
Understand.
bias. So
And these actions begin with, I'm assuming, a visit by a code compliance officer.
Correct.
To the property. Okay.
Okay, then my question is, can we call code compliance every day? The last time I spoke to Nick was about a month ago, and I said, can you please come by and at least take pictures of what has happened here? And he said to me, no, because I can't put those pictures in the board meeting that's coming up, or we would have to postpone and have it go on to another month. And then that would be December, and there's no meeting, and then there would be January. So even when we call code compliance, I call the cops as well. So I don't know who to call first, code compliance or the city cops.
Okay.
And the
I
car,
could just make a comment after you.
okay, and the car, it does go from the backyard to the front yard. Now it's dead, but his new car then went from the front yard to the backyard on a regular basis. So his cars are an issue ongoing. His garbage and his grass are issues ongoing.
All right. Here we're dealing only with the issues that have already been brought forward by the code compliance team. That's just the way the process works. I know it's frustrating to you.
So,
Please, I have no power to order the code compliance team to do anything, but I would suggest that, Officer Price, for your remaining time, perhaps yourself or designate someone that the members of this neighborhood could reach out to and make visits as requested at a reasonable time.
Ma'am, could I?
So
Go ahead, Mr. Price.
we are limited with staff.
I understand.
There are, Nick has close to 100 open cases right now. He's only one person. I understand that the property is a hot topic right now. We have been by, he has been by, I've been by. Getting someone out there is kind of difficult sometimes, but we make it happen. But I believe what they're stating is we can't go by and keep documenting the same violation over and over again. When they say there's more outside storage, we're already taking it back for outside storage. We can document it, but it's still going to be the same violation. It just shows the amount that he has, and I think the evidence that is on the property is significant enough to let you know. You see pictures when the stuff is there, then it's moved. It's an ongoing issue. We're aware of it. We want compliance. Unfortunately, we can't make anybody do anything. All we can do is what we're doing right now.
All right, let me ask Mr. Lewis. If the board finds that the owners violated the code with regard to outside storage, is that finding broad enough to encompass things that come and go? Or because, I mean, it appears that there have been items that may have been outside storage in violation of the code. Those items disappeared, they come back again. Is the board's order broad enough to encompass things of that nature? Or do you have to be specific as to what constitutes the outside storage?
So no, you don't. We do a cease and desist for outside storage, that sticks with the property for a number of years. So if he does it again, it comes straight back to the board.
Okay, it sticks with the property for how long?
5 years.
5 years?
From the
Okay,
date-
so if
from the
there's
date
an
that it's
order
issued.
to cease and desist from outside storage, that order remains in place for a period of 5 years.
Same thing with any order that you give. So it comes right back to the code board. And
Okay.
we have had cases where it comes back to
I recall
or back
cases
to the-
where
to
things
the
come
code
back
board.
and then people are given new orders again.
Could we just request a solution possibly? If the officer is not able, then I get it, there's resources. Is there a way to, I have videotaped him doing his ride, so my point is there a way for us when there's a violation to at least email the compliance officer on a date to where then it's at least confirmed?
Well, you can contact the board, but citizen complaints are not taken by the code compliance board. It has to come through the code compliance staff, so you need
I'm just
to-
looking for a solution to, with your resources
Right.
being limited, utilizing technology, that would be just an email to show the date of him with the junk, whatever it is, the two violations we're speaking of.
I see what you're saying.
just looking for a solution.
That you make a record of a specific
That's all.
action at a specific day.
Yeah.
Yes.
So yeah, yes, all
Yes.
code enforcement cases, if there's information, it has to go to the code enforcement
Staff,
officers,
right.
so that it can be investigated and determined whether or not to even be brought before the board.
Correct. Right. So I think, yes, I think the short answer to your question is yes.
Thank you, and thank you again. I mean, just the fact that the amount of time you do for the community and everything else. Here's what I would just ask. I sat here this morning, and there was a violation on the first case of a citizen for 12 years here that had what was considered a clean license. And I saw that he was guilty of the violation. If he parked that car out there again, I am certain, based on what happened today, the board would have then charged him and made him guilty again and probably charged him the $100 or $200, whatever that number was, if he did it again tomorrow. So I don't understand the circumstances, and I'm not a lawyer, where the board looks at a citizen that had 12 years here, was a good citizen and a healthcare worker, et cetera, and we have the situation that we're dealing with that's repetitive, and I just don't understand how that differentiates. So I guess that's just something to consider as you all consider how to handle this, because it's not good for the community. Thank you.
Thank you.
If I might. So, with respect to the two categories of violations that are before you today, the tall grass and weeds and the outside storage, we have a good handle on how to deal with that if it is repetitive. And as was already described, we bring it in, assuming your motion includes and the order includes a cease and desist, we can come back in and fine the property owner for every time they've violated your order to cease and desist. Now, there are, and I won't be specific, but obviously you've heard that there's another concern that the property owners have about the vehicle that may come and go. All right. Initially, he was cited for having that vehicle in the backyard, and he remedied that violation by taking it out of the backyard. The problem is, and I'll remind you of the Emerald Lakes case, where the testimony was from residents who were testifying principally with respect to the inoperable or missing night lights.
Street lights.
And that only the residents could provide that testimony under normal staffing. And so we allowed them to come in to assist the code enforcement officer in presenting their case by providing evidence that they could testify to, but it wasn't the code enforcement officer wasn't capable of testifying with respect to their own personal knowledge. All right. That case is presently on appeal, and one of the arguments that was made on appeal was that it was legally inappropriate for the city to bring in as like volunteer code enforcement officers to present testimony in this and before you, and then you make findings from the citizens that didn't come from personal knowledge of the code enforcement officer. I have argued that what was presented to you in the fashion that it was presented was legally appropriate. But I'm reluctant to say that we can continue to do that and invite the residents to document when the car, for example, is in the backyard, and then come before us and have the code enforcement officer utilize that testimony to make the case. I think it's legally appropriate for us to do that, but in view of the fact that it is presently on appeal, I'd like to have that case, that hear what the judge has to say about our legal argument that is legally appropriate, rather than continue to create that legal argument with uncertainty that may require us to go back in court in another case to defend that action. So that's the dilemma.
Yes, I understand. And I leave it up to the discretion of the city and the city staff to determine what to do with this information.
And so we are sensitive and mindful of the concern. And to the extent that we can address it directly, I think we will attempt to do that. But if we don't see it, that may be problematic until we get a ruling from the court.
Understand. And do you have any idea of the time frame that the court will take? I know it's on appeal. I know the briefs have been submitted.
And we have been given no indication from the court as to when they are going to either have oral argument, if they're going to entertain that, or make a decision. So we have no information whatsoever.
Okay. All right. Thank you. Ma'am?
That's the last thing I
Briefly.
wanted to speak to, is that when I called code compliance the first time about this, they said, please send pictures. Did so. Nick, when he came to our house yesterday to take more pictures, and we brought up that car that is inoperative, and that we have a picture that shows it has no license plate, Nick said, we can't accept
Madam Chair, I'm sorry, again, we can't accept third-party pictures, so do you accept them or don't you? Well, at this point, ma'am, we are in the middle of a quasi-judicial hearing. Again, it's not a question and answer, it's not public comment. This board has to just hear testimony as to the case, as to the charges that are before it here today.
Great. Okay. All right. Okay, anything else, Mr. Faulkner?
No, just after this case has determined a ruling, I would like to speak with you guys briefly after the case.
Great.
To kind of go over new information. Okay.
As well, I'm wondering, so at what point then does this get taken to the judge? When does it become a legal process?
Right now.
All right. Mr. Lewis, why don't you answer that?
The board is the judge right now. This board is the trier of fact in this matter. We are in a quasi-judicial hearing, so this board will make the determination whether or not there was a violation of the city code. And if there was a violation of the city code, whether or not to give time to correct that, and then if there has been no correction, whether or not a fine should be put in place. Ultimately, it would be if that's what is present here before the board today. And that's what we have to hear testimony on, because there are any respondents, present or not, have a right to an appeal of any action that for 30 days after the fact that this board determines.
And so who determines those timeframes?
That's set by the state law and the ordinance.
That is state, yes.
All right, thank
Okay.
you.
I'd like to make a motion.
All right, I'll entertain a motion.
I'd like to make a motion the city has established a prima facie case.
Is there a second?
I'll second that.
All right, is there any discussion? All right, all in favor signify by saying aye.
Before we do that, can you restate the motion? I didn't hear it.
The prima facie case.
Prima facie case.
All right, any opposition? All right, let's do a vote again. Signify by saying aye.
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 Any
Aye.
opposition? All right, the motion carries. The city has established a prima facie case. Is there anything further before a vote on whether the respondents violated the code? All right, I'll entertain a motion on that then.
Okay. I move that the respondents violated Chapter 9, Section 9-2H of the Punta Gorda Code, and Chapter 9-2A, and issue a cease and desist order for any future violation of the Punta Gorda Code. Chapter 9, Section 9-2H of the Punta Gorda Code, and Chapter 9-2A of the Punta Gorda Code, in order that the respondents bring the property into compliance within 60 days of the receipt of this order. And it is further ordered that the respondents are required to pay case costs in the amount of $22.07 within 15 days of the receipt of this order. It is further ordered that failure to comply with this order may cause the Code Enforcement Board to impose a fine of up to $250 per day plus applicable interest. And I use the term 60 days just because of the logistical issues involved in this, and the availability of people and machinery and whatnot, and what it would take to clean this up. And also understanding the process that we've seen go through before. So that's.
All right, is there a second or any discussion?
I'd like to make an amendment to that motion.
All right,
Do I have to read the whole motion, or can I just say,
just say what you wish to amend, I think.
I'd like to change that to bring it into compliance within 15 days?
Please.
We got to talk about that.
I don't want any outbursts or any discussion from the members of the audience. The time to speak has passed. You were at the podium. We entertained your thoughts. I appreciate your thoughts, but this is a matter for the board, not for the public at this moment. Thank you. Go right ahead.
And I say that because I understand you're talking about with equipment, but we're talking about tall grass and outside storage. There's not a lot of equipment that's going to be needed for that. They just need to just pick stuff up and mow the lawn.
Can we have a discussion before?
Yes,
So,
any discussion?
the issue with that amendment would be twofold in my mind. One, it would be very difficult to get a large quantity of work done at a home in 15 days. And two, our past practices really don't align with 15 days. We've done 30s, if it's a small job, 60s, but we haven't done that to other residents in Punta Gorda.
What's so big about this job that we're looking at for the tall grass and weeds and the outside storage? I mean, things are able to be picked up and moved.
Well, we're just coming off of storms. And if this person's going to use a contractor, contractors are not that easy to come by. And if we made it 15 days, all you're really doing is giving the person an opportunity to say, you didn't give me enough time, and now you're trying to find me.
I agree, and part of this is based on past experience in the last several years on this board. You know, something needs to be enforceable, to be effective. It doesn't do any good to say, do this if you can't enforce it. And if we say 15 days and nothing's done, have we really affected change? 60 days, I think, is overly lenient, but it looks at the realities of finding a contractor. Yeah, mowing the grass is relatively simple, if the individual is motivated to do it, you know.
Well, if they don't do it within the 15 days, then we can impose the fine of $250.
However common.
Not until the next meeting of the
This
board.
probably wouldn't happen till January, because we're not gonna meet in December. So it'll be January board, so it'll be February, you know, before something happens. You know, so 15 days is relatively loose because of the process, because you have to go through the process. Due process is accorded at each step in this. Yeah, if you had a team of 10 or 15 people, they could probably get it done. But again, based on past experience we've had on things like this looks like it has all the potential of being another Rat House or one of the others, Ocean Drive, or
Right.
one of the others we've had that gets extended out into months and even years.
Does 60 days get us before the next meeting?
No.
See, that would be the one comment I would have. It would be good if we could pick a time frame that is sufficient to get the work accomplished, but prior to our next meeting, so it could be re-inspected, and in January, we could be looking at this
It could come
again.
before the board for the January meeting. I agree with that.
I'm amenable to modifying that to 45, 30, 45.
Either will do.
Okay, amending my motion of 60 days to 30 days so that it can meet the next board.
Madam Chair, the cutoff for the January hearing is January 2nd.
Okay, well, 30 days would be January 2nd if you get that order out soon. Because it's from the receipt of the order, correct?
The orders go out same day.
All right, but we have a holiday tomorrow, so
But
they
it's-
have to get into the mail today.
Yeah, the orders go out same day, but it's when they receive it.
Understand?
Okay.
You're amending the motion to
I'm
30?
amending my motion as read, except amended 30 days of receipt as opposed to 60.
Second the motion.
All right, any discussion? All right, I will say that 30 days gives the staff the opportunity to get some feedback before the next meeting, and I suspect this is going to be a matter that the board is going to have to take some cognizance of over the next few months. So, all right, all in favor signify by saying aye. A motion has been made and seconded with 30 days and paying case costs within 10 days. Is that what the? 15, pardon me. 15 days. Motion has been made and seconded. Any further discussion? All in favor signify by saying aye.
Madam Chairman, I do have a question.
And I'm sorry, who's there? Oh, I'm sorry.
May I ask a question here?
Yes, of course.
When does the $250 a day start?
It starts on violation of the order. So they have to violate the order, and then it has to come back before the board, and the board imposes the fine.
Okay, so some consequence for the benefit benefit of those who
ordinance.
have complained.
Yes.
Roger on that.
Yes.
Thank you.
So statutorily, this is a statutory process, Mr. Lewis, right?
Yes, so it says this was, this is, from my review of all the notifications, it's essentially a first-time violation in terms of, for your purposes.
Correct.
Which means that you issue the order, you give time to correct, and if there is no compliance within that time that you've given them to correct, then it comes back for a hearing, and then from that date of violation, from when they were supposed to have it corrected by, that is when your $250 a day fines can begin.
Starts.
Yes.
And we will have cases later in this session which will illustrate that. If
Yes.
anybody wants to stick around to see that. Right. All right. So the motion has been made and seconded. Let me review: to bring the property into compliance within 30 days of the order and to pay the case costs incurred in the amount of $22.07 within 15 days of the order. Is there any further discussion? All in favor signify by saying aye.
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 Opposed, nay. The motion carries. The board has found that the respondents violated Chapter 9, Section 9-2H of the Punta Gorda Code and Chapter 9, Section 9-2 Alpha of the Code, and has issued a cease and desist order for any future violations of these section of the codes, and orders that the respondents bring the property into compliance within 30 days of receipt of the order. And it is further ordered respondents required to pay case costs incurred in the amount of $22.07 within 15 days of the receipt of the order, and further ordered that failure to comply with the order may cause the Court Enforcement Board to impose a fine of up to $250 per day plus applicable interest. Members of the community, I thank you for your interest, and I thank you for your testimony today. It is our hope, it is always our hope that the actions of the board and the city staff bring people into compliance. The goal is compliance and not sanctions. So let us work toward that. Thank you.
Madam Chair, if we might move up or move down 3A so that staff can go and meet with the citizens for a few minutes, so that 3B would be the next case, and we'll come back to 3A when they are done with it.
Sure. So 3B being the next one?
Yes.
Okay.
I just have a procedural question. When we do this, and there's a separate, obviously separate date for the compliance and then the case costs, what happens if they don't pay the case costs? Or how do we track that? Who do they pay that to, and is that tracked?
Code Compliance Supervisor Lavoisier Price is added to when we bring it back for penalty.
So
The
they-
additional case cost?
Yes, sir.
It's case cost plus case cost incurred that you hear sometimes. That's where the case cost is added to.
That goes
But
on the lien,
ultimately, if
too?
they don't pay any of it, it is added to the lien
Okay,
when we send it to be recorded and everything. So
so that would come back to us again if they don't pay this. the
you'll
next
see,
time.
you'll see it
10:30,
coming up
yes.
here shortly.
Okay.
Case cost incurred plus
All right,
additional case
yeah.
cost. So.
All right, now, let's take a 5-minute break, I think, for comfort. Thank you. Okay, thank you. We've had a short break. The next item is a hearing imposing penalty, case number 23-84764, Code Compliance Officer Nick Faulkner. Respondents Walter and Mary I. Hunzenga. Address of violation 2559 Brasilia Court, violation of Chapter 26, Section 8.11B, structure in disrepair. Are the respondents present? Are the respondents present? All right, the respondents are not present, so I will enter a plea of not guilty on their behalf. Mr. Faulkner.
For the record, Nick Faulkner, Code Compliance Officer for the City of Punta Gorda, and I have been sworn. This matter was before the board on September 27th, 2023, at which time the board heard testimony, received evidence, and entered its compliance order, which was sent to the respondents via certified return receipt mail on October 2nd, 2023, and returned undelivered on October 27th, 2023. That on October 2nd, 2023, the compliance order was posted on the property and at City Hall Annex. Said compliance order required the respondents to have the garage door repaired or replaced and a permit be applied for within 30 days of receipt of the order, and to cease and desist from any future violations of the Punta Gorda Code, Chapter 26, Section 8.11B. On November 6th, 2023, subsequent reinspection of the property at 2559 Brasilia Court found that the garage door remained in a state of disrepair and no permit application had been applied for, and the property remained in noncompliance. On November 8th, 2023, an affidavit of noncompliance and notice of hearing imposing penalty was mailed to the respondents via certified return receipt mail, which was received on December 13th, 2023. On November 8th, 2023, I posted said affidavit of noncompliance and notice of hearing imposing penalty on the property and at City Hall Annex. On December 12th, 2023, I re-inspected the property and found that the garage door remained in a state of disrepair and no permit application had been applied for, and the property remained in noncompliance. On December 13th, 2023, the December Code Enforcement Board meeting was canceled. On December 13th, 2023, a notice of continuance to the January 24th, 2024 Code Enforcement Board meeting was sent to the respondents via certified return receipt mail, which was delivered on January 7th, 2024. On December 13th, 2023, the notice of continuance was posted on the property and at City Hall Annex. On December 3rd, 2024, I re-inspected the property and found that the garage door on the house structure of the property remained covered by plywood in a state of disrepair, and the property remained in noncompliance. On January 24th, 2024, the board found that the respondents were in violation of its compliance order and ordered that a fine in the amount of $2,975 be imposed, representing a fine of $25 per day for 119 days of noncompliance from September 27th, 2023 to January 23rd, 2024, plus applicable interest of 9.09% per annum, and was further ordered that the respondents required to pay unpaid case costs in the amount of $25.35, plus additional case costs incurred in the amount of $44.86, for a total cost incurred in the amount of $70.21. On January 25th, 2024, the hearing opposing penalty was mailed to the respondents via certified return receipt mail, which was received on February 8th, 2024. On January 25th, 2024, I posted said notice of hearing imposing penalty order on the property and at City Hall Annex. On September 17th, 2024, a subsequent reinspection revealed that the corrective action ordered by the board had not been taken, and that the garage door on the house structure of the property remained covered by plywood and in a state of disrepair, and the property remained in noncompliance. On September 18th, 2024, an affidavit of noncompliance and notice of hearing imposing additional penalty was mailed to the respondents via certified return receipt mail, which as of October 19th, 2024, had not been returned or delivered. On September 18th, 2024, I posted said affidavit of noncompliance and notice of hearing additional penalty on the property and at City Hall Annex. On October 16th, 2024, a notice of continuance to the November 27th, 2024 Code Enforcement Board meeting was sent to the respondents via certified return receipt mail, which as of November 22nd, 2024, had not been returned or delivered. On October 16th, 2024, I posted said notice of continuance to on the property and at City Hall Annex. On November 26th, 2024, I re-inspected the property and found that the garage door on the house structure of the property remained covered by plywood and in a state of disrepair, and the property remained in non-compliance. The property has been in violation of the compliance order for an additional 308 days of non-compliance from January 24th, 2024 to November 26th, 2024. Submitting 4 photos for the record. The pictures submitted for evidence are a true and accurate representation of the condition of the site at the time the pictures were taken. I'm submitting an invoice for unpaid case costs in the amount of $70.21, plus additional case costs incurred in the amount of $56.19, for a total case cost incurred in the amount of $126.40.
I have a question for our attorney before we start this.
Go right ahead.
For our attorney, I've had a resident discuss this property with me. Do I need to recuse myself from this discussion in this proceeding?
So you had a resident ask you a question?
A resident was asking me what is being done and when we're going to take action, and was telling me that no one's doing anything on the property.
So this would be considered ex parte communication. Does that in any way affect your ability to be fair and impartial?
No, they didn't discuss anything about the owners, just that the garage door is a mess and that no one's doing anything.
As long as you can put on the record, state on the record that you can be fair and impartial in this order imposing fines, then an ex parte communication does not disqualify you and does not require you to refuse it.
Okay, thank you.
Okay. Mr. Officer Faulkner, just to sum up, they are currently under an order for noncompliance, and fines are accruing.
That's correct.
And at what rate are the fines currently accruing?
$25 per day.
$25 per day, and they have been accruing since
September 27th.
308 days.
September 27th, 2023, right?
Yes.
Okay, because I'm looking at the record here. I have 119 days of noncompliance from September 27, 2023 to January 23, 2024.
That's correct.
Okay.
And those orders have been recorded.
Those orders have been recorded.
So now
Okay.
we can
And
oppose
so now we're going
additional
from
penalty.
January
And now this matter is before us for additional penalty,
From January
correct?
24, 2024 to today.
To today,
Which is 308 days.
which is 308 days. And the only violation in this case is this garage door, correct?
That's correct.
And do people live in this house?
I'm unaware of that information.
Code Compliance Supervisor Lavoisier Price Jr., and I have been sworn. So I spoke to the property owners this week.
Oh,
They
good.
are not here. They are in Michigan. She's attending to
They're
her.
where?
Michigan.
Okay.
She's attending to her husband. So no one lives there.
Okay. And this hasn't gotten their attention yet?
Yes.
It has gotten their
One of
attention.
the neighbors, I guess, sent her a picture of the violation that was in front. So they are aware. They're attempting to sell the house. They do have a contract to have the door, the garage door replaced, but a permit has not been submitted yet or applied for or approved, which is what
They
we
need
want.
this, they need a permit to get a new garage door?
Yes.
Okay.
Mr. Price, this has been pending since more than a year.
Yes.
Were they aware that there was these fines accruing?
I am not sure of that. I did let her know that there were already fines and would be more, and she was interested in paying them because they're gonna sell the house.
I have a question. Who's responsible for applying for the permit? The owner here or the person with whom she is contracted?
It depends, it's between them. In this case, she said the contractor would.
Okay, so basically the contractor is non-compliant, is dragging his feet.
No, she is. It's still the property owner. It's always the property owner. Property owner is responsible for their property. So
Right.
indirectly, yes, but
Wow, I think right now the fines are more than a new garage door.
Yeah.
Yes. Quite a bit more.
All right, Mr. Faulkner, anything else? Is there anyone-
Nothing else?
All right. All right, I'll entertain a motion.
I'd like to make a motion, and I would try to state that the conversations I did have with the individuals have no impact on my opinion. I'd like to make a motion that the residents are in violation of the compliance order in order to pay a fine in the amount of $30,800 be imposed, representing a fine of $100 a day for an additional 308 days of noncompliance from January 24th, 2024 to November 26th, 2024, plus applicable interest of 9.5% annum, and said fine shall continue to run until respondents come into compliance with the Punta Gorda Code. It is further ordered that the respondents are required to pay unpaid case costs in the amount of $70.21, plus an additional case cost incurred in the amount of $56.19 for a total of $126.40 within 30 days of receipt of this order. It is further ordered that failure to comply with this order may cause the Code Enforcement Board to impose a fine of up to $250 per day plus applicable interest. And the reason I picked $100 a day is it's an elevation from previous. They have taken some action to try to do it, but it's way overdue, and it's been going for way too long, in my opinion. And that's where the $100 came from. Originally, I was thinking 200, so that's my motion.
All right, and I'm sorry, I didn't note when they need to pay the case costs?
30 days.
30 days. Is there a second to the motion or any discussion?
Second.
Any discussion? I will say that it's steep, but we've had more than a year of foot dragging and non-compliance. And I'm assuming that if they come into compliance, they can come back to the board and ask for a reduction in the fine?
Yes, that's what I was going to advise.
Right, all right.
and they are aware that they can come back for a reduction.
Perfect, thank you so much. All right, so there's been a motion made and seconded. Is there any further discussion?
How much did you say it was total?
Total?
30,000?
It's an additional, it's $30,800.
And that continues to run. That's just for up to today, correct?
That's correct.
It continues to run at the rate of $100 a day. All right, that is very steep. Okay, a motion has been made and seconded, and is there any further discussion? I'll call for a vote. All in favor signify by saying aye.
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 Any opposition? The motion carries. The board has found that the respondents are in violation of their existing compliance order and orders that a fine in the amount of $30,800 be imposed, representing a fine of $100 per day for an additional 308 days of non-compliance from January 24, 2024 to November 26, 2024, plus applicable interest of 9.50% per annum, and said fine shall continue to run until the respondents come into compliance with the code, and it is further ordered that the respondents are required to pay unpaid case costs in the amount of $70.21 plus additional case costs incurred in the amount of $56.19 for a total of $126.40 within 30 days of receipt of the order. And it is further ordered that failure to comply with the order may cause the Code Enforcement Board to impose a fine of up to $250 per day plus applicable interest. Thank you. All right, the next matter, hearing imposing penalty, case number 24-85640, Code Compliance Officer Meredith Ochtenberg, respondents Brian Ross Orme, Life Estate, address of violation 419 San Marie Drive, violations alleged at Chapter 26, Section 8.10, parking of trucks, trailers, and RVs, Chapter 9, Section 9-2, Alpha, outside storage, Chapter 26, Section 8.14B, outside storage, and Chapter 26, Section 8.11B, property maintenance structure. Are the respondents present? Are the respondents present? All right, the respondents not being present, I will enter a plea of not guilty on their behalf. Officer Ochtenberg.
For the record, Meredith Ochtenberg, Code Compliance Officer for the City of Punta Gorda, and I have been sworn. This matter was before the Board on June 26, 2024, at which time the Board heard testimony, received evidence, and entered its compliance order, which was mailed by a certified return receipt to the respondent on June 26, 2024, which was returned undelivered on July 2, 2024, and was posted on the property and at the City Hall Annex on June 26, 2024. Said compliance order required the respondent to have the 4 or more trailers removed from the property, the outside storage removed throughout the property, and the missing and/or damaged soffit and siding be repaired or replaced within 90 days of the June 26, 2024 Code Enforcement Board meeting, and to cease and desist from any future violations of the Punta Gorda Code, Chapter 26, Section 8.11b, Chapter 26, Section 8.10, Chapter 9, Section 9-2A, and Chapter 26, Section 8.14b. On September 24, 2024, subsequent reinspection of the property at 419 San Marie Drive found that the 4 or more trailers and outside storage remained throughout the property, and the missing and/or damaged soffit and siding remained on the property. On October 1, 2024, an affidavit of noncompliance and notice of hearing imposing penalty was mailed to the respondents via certified return receipt mail, which was returned undelivered on October 5, 2024. On October 1st, 2024, I posted said affidavit of noncompliance and notice of hearing imposing penalty on the property and at the City Hall Annex. On October 15th, 2024, a notice of continuance was mailed to the respondent via certified return receipt mail, which was returned undelivered on October 21st, 2024. On October 15th, 2024, I posted said notice of continuance on the property and at the City Hall Annex. On November 26, 2024, a reinspection of the property found that the excess of trailers had been removed from the property. However, the outside storage remained throughout the property, and the missing and/or damaged soffit and siding had not been repaired or replaced, and the property remained in non-compliance. The property has been in violation of the compliance order for 154 days of non-compliance from June 26, 2024 to November 26, 2024. I am submitting 19 photos for the record. The pictures submitted are a true and accurate representation of the site at the time the pictures were taken. I am also submitting an invoice for unpaid case costs in the amount of $53.35, plus additional case costs incurred in the amount of $66.39, for a total case costs incurred in the amount of $119.74.
Any questions for Ms. Ochtenberg? You indicated that all of your notices, the compliance order, the notice of hearing, and the continuance notice were undelivered, returned undelivered.
That's correct, which is why they were also posted on the property.
And are you satisfied about the notice with regard to the notices were all posted on the property, that was all done correctly?
Yes.
Okay, question.
Maybe just so this is here, this was one when it occurred, we sort of said, okay, here it comes, this could be another one of those, and it's proven true. So, and I'm asking this as a matter of procedure then, is there anything we can do that may be outside the realm of the standard going down the procedural path offered to us here? And I'm thinking by way of finding it to be a threat to the public health, safety, and welfare, and be able to do something a little bit more proactive than reactive in terms of what we can do in this situation?
Good morning, Rachel Berry, zoning official for the record. Staff would like to ask the Code Enforcement Board to request the City Council to direct the City Attorney to investigate pursuing an injunction in Circuit Court as a public nuisance.
Okay, so I was...
Well, there's your answer.
It doesn't matter, but I was looking at Chapter 162 of the Florida State statutes and what we can do or possibly could do when I was thinking about this. And there's actually provisions in there that if they find it to be such, that the governing body, that being city council, could make all reasonable repairs to the property to bring it into compliance, and that may be towing it away. And then put that in as part of the fine or the lien to the violator. And as I said, I'm just looking for something that I agree that we need to pursue something a little bit more aggressive than the standard tax, because I don't think it's going to have much effect on the property owner here. So, first of all, the comments of the zoning official would be supplemental to the fine that we are requesting. So we want to make sure that there is a fine imposed.
Sure.
But, and I am familiar with the provisions of the statute that you're referring to. And I think that would be more suited to if we had to go on the property to mow, if we had to go on the property to remove vegetative debris and things of that nature. But in order to remedy this violation would require the city to go on there and remove and dispose of personal property. And my concern with respect to implementing the provisions of the statute in that regard could subject the city to unnecessary liability. That's why the suggestion would be to request the city council to seek a public nuisance and have a court order the removal of that stuff, and that order can then be enforced by way of sanctions such as contempt. And that takes the part of the liability out of the city's hands, and the judge has the authority to make that type of decree. Yeah, that's fine. I was just looking for a way to kind of move this along instead of having it stagnate and just coming back again and again.
Well,
So
I will suggest that no matter what the city does, it's going to take a little bit of time, but on the good side of things, you heard testimony that all but one of the trailers have been removed. So we are making progress.
Yeah.
Code Compliance Supervisor Lavoisier Price Jr. Also, to add to that, we are mowing the grass. It is a distressed property. We have been mowing it, so that's one thing that we have done since the last code board meeting to kind of remedy the problem. Oh, yeah, yes, they're being charged for it.
Are you the ones that were removing the trailers, or
No.
was somebody in the...
No, that was somebody else.
somebody in
All
the
we're
family?
doing is mowing the grass.
Okay, thank you.
Again, Daniel P. Lewis, just to put my 2 cents into it. Yeah, it's considering we are in a penalty phase as opposed to a hearing on compliance phase, where I would tend to agree with the city attorney on this. The city would have to actually bring the evidence of threat to harm health, safety, and welfare to make that determination. But we're in a penalty phase. We're not even at that stage. We're kind of beyond that stage at this point. So the recommendation of I go along with Mr. Levin in that probably that a court injunction is probably the better way to go about it.
Are they currently under a fine for noncompliance? I can't find it in the record. No. No, okay. So this would be the first fine for noncompliance?
Correct.
Okay.
So I would make the motion that the city asked for, except I would need the wording.
That the city,
Yes.
that the city requests city council, or the, go ahead.
I would just want it to be worded correctly.
If you could repeat your request, please.
Rachel Berry, again for the record. So in addition to any other motion the board makes, we would request that the Code Enforcement Board request the City Council to direct the city attorney to investigate pursuing an injunction in city court as a public nuisance.
I make that motion.
All right, let's work on that motion first, and then we'll work on the fine. All right, there's been a motion that the Code Compliance Board requests the City Council to direct the city attorney to investigate and to take action pursuant to To pursue an injunction to declare the property a public nuisance. That motion has been made. Is there a second?
I second.
All in favor signify by saying aye.
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 Any opposition? The motion carries. Okay, so the the Code Enforcement Board requests the City Council entertain such action. Let's talk about the compliance order. I'll entertain a motion regarding the compliance order.
I'm ciphering.
It's just a point of reference, does it, not making a judgment either way, does it make any sense to order?
Yes.
Compliance, well, apparently there's been some movement, so things have been taken off, so maybe that'll help.
Okay.
And certainly, if finally the attention of the property owner has been received, we would prefer that they bring the property into compliance before I have to seek an injunction at the cost of the city.
Right, right.
Thank you, Mr. Levin.
That's a good point, too.
Okay, I'll make a motion.
All right.
I'd like to make a motion, the respondent is in violation of the compliance order in order to pay a fine in the amount of $7,700 be imposed, representing a fine of $50 per day for an additional 154 days of noncompliance from June 26, 2024 to November 26, 2024, plus applicable interest of 9.5% annum. Said fine shall continue to run until respondent comes into compliance with the Punta Gorda Code, and is further ordered that the respondent is required to pay unpaid case costs in the amount of $53.53, plus additional case costs in the amount of $66.39, for a total of $119.74 within 30 days of receipt of the order, and is further ordered that failure to comply with the order may cause the Code Enforcement Board to impose a fine up to $250 per day plus applicable interest. And I picked the $50 per day as a lower point because there has been some movement, and we're citing the fact that there has been some success.
All right. Is there a second? All right. There's been a motion and a second to impose a fine in the amount of $7,700, representing a fine of $50 per day. Is there any further discussion? All right. All in favor signify by saying aye.
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 Any opposition? The motion carries. The board has found that the respondent is in violation of the compliance order and orders that a fine in the amount of $7,700 be imposed, representing a fine of $50 per day for an additional 154 days of non-compliance from June 26, 2024 to November 26, 2024, plus applicable interest of 9.50% per annum, and the said fine shall continue to run until the respondent comes into compliance with the code, and is further ordered that the respondent is required to pay unpaid case costs in the amount of $53.35, plus additional case costs in the amount of $66.39, for a total of $119.74 within 30 days of receipt of this order. And it is further ordered that the failure to comply with the order may cause the Code Enforcement Board to impose a fine of up to $250 per day plus applicable interest. Okay, next item, hearing imposing penalty, case number 24-85681. Code Compliance Officer Meredith Ochtenberg, respondent Aaron Doby, address of violation 710 Monaco Drive, alleged violation Chapter 9, Section 9-2D, vehicle inoperable, unregistered. I understand there's a motion from the city.
Meredith Ochtenberg, Code Compliance Officer for the City of Punta Gorda, and I have been sworn. That's correct, a motion to dismiss. During reinspection yesterday, I was unable to view the violation.
You were unable to see the violation?
Correct.
Tell me about that.
The vehicle is inoperable. It has the violation is a flat tire, the front passenger side. There are leaves blocking my view of the tire, that portion of the vehicle.
How about unregistered?
There is now a registered plate on the vehicle.
So we don't know that the individuals in compliance at this point?
Code Compliance Supervisor Lavoisier Price Jr., I have been sworn. So we can't see that the tire is flat, probably purposely put leaves in front of the tire, saying that we can't view the violation and say that it is. We can't assume that the tire is still flat. Therefore, that's why we're asking for dismissal.
Why would we not continue this matter and re-inspect before the next meeting of the board?
If you wanted to do that, we could do that. But we can do that if that's what the board wants. Continue it to the next matter.
All right, well, let's since we are discussing, rather than just acceding to a motion to dismiss, let me just put on the record, is the respondent present? And is the respondent present? The respondent is not present. Any thoughts from the board?
I agree with you. Given another, who knows, couple weeks, maybe the leaves will blow away and we'll be able to see if there's a tire or not. I would rather wait a little bit.
He has also had toys placed in front of it before that. So
He also had what?
toys placed in front of it before that. So
Toys.
he may know
You think?
what he's doing.
Sorry.
Well, I think keeping him on the hook is very
Yes,
good.
I don't agree with dismissing the motion for that reason. I would rather keep it open and kind of keep an eye on things, would be my discussion point.
I would make a motion, we continue this to the January meeting.
Is there a second?
I'll second that.
All right, is there any further discussion? All right, I would like to just emphasize that if we continue this to January, that the code enforcement staff do what's necessary with regard to informing the resident of a hearing and re-inspecting the property to make sure everything's fine for the next meeting.
They need to understand that the compliance order was issued a long time ago. If they're still in non-compliance, any fine we give them is going to be hefty. Because it's going to be, it's 5 months now since they received the order.
I know. How much does it take to repair a flat tire?
A lot less than it's going to cost for a fine.
All right, a motion has been made and seconded to continue this to the January meeting of the board. Is there any further discussion? All in favor signify by saying aye.
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 Any opposition? The motion carries. This matter is continued to the next meeting. Thank you. Next item, hearing imposing penalty, case number 24-85891, Code Compliance Officer Meredith Achtenberg, respondent Brenda Berkemeyer, address of violation 7212 North Blue Sage, alleged violation Chapter 26, Section 8.11G, property maintenance storage. I understand there's a motion from the city. Officer Achtenberg.
For the record, Meredith Achtenberg, Co-Compliance Officer for the City of Punta Gorda, and I have been sworn. That's correct, a motion to dismiss. The code that was cited was property maintenance disrepair. It has since been, an attempted repair has been made, however, with an unpermitted material. So, which is a different code. So a new case will be open, a new case will be initiated with the correct code now.
Okay. Mr. Camo.
Is there a permit required for this?
Code Compliance Supervisor Lavoisier Price Jr. and I have been sworn. It depends on the size of the offense that they make. Up to a certain size, they would not need it.
Thank you.
So what I think I'm understanding is that the city wishes to dismiss this action, but is going to initiate action under a different code section.
Correct.
I make a motion, we dismiss case 24-85891.
Is there a second?
Second.
Any further discussion? All in favor signify by saying aye.
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 Any opposition? All right, the motion carries. This matter is dismissed, and we'll leave it to the city's discretion with regard to further action. All right, next item, hearing imposing penalty, case number 24-85856, Code Compliance Officer Nick Faulkner, respondent John I. O'Donnell, trustee, address of violation 2035 Jamaica Way, violation of Chapter 26, Section 8.11B, property maintenance structure. Is the respondent present? Is the respondent present? All right, the respondent not being present, I will enter a plea of not guilty on the respondent's behalf. Mr. Faulkner.
For the record, Nick Faulkner, Code Compliance Officer for the City of Punta Gorda, and I have been sworn. This matter was before the board on July 24th, 2024, at which time the board heard testimony, received evidence, and entered its compliance order, which was mailed certified return receipt to the respondent on July 24th, 2024, which was returned undelivered on August 13th, 2024, and was posted on the property and at City Hall Annex on July 24th, 2024. Said compliance order required respondent to have the damaged and/or missing siding, torn and/or missing pool enclosure screens be repaired or replaced, and the exterior holes in the soffit near the front entryway be repaired within 60 days of the July 24th, 2024 Code Enforcement Board meeting to cease and desist from any future violations of the Punta Gorda Code, Chapter 26, Section 8.11B. On September 23rd, 2024, I re-inspected the property at 2035 Jamaica Way and found that the damaged and/or missing siding, torn and/or missing screens on the pool enclosure, and the holes on the exterior soffit near the front entryway remained on the property. On October 1st, 2024, an affidavit of noncompliance and notice of hearing imposing penalty was mailed to the respondent via certified return receipt mail, which has not been received or delivered as of November 4th, 2024. On October 1st, 2024, I posted the affidavit of noncompliance and notice of hearing imposing penalty on the property and at City Hall Annex. On October 16th, 2024, a notice of continuance was mailed to the respondent via certified return receipt mail, which was returned undelivered on November 16th, 2024. On October 16th, 2024, said notice of continuance was posted on the property and at City Hall Annex. On November 26th, 2024, I re-inspected the property and found that the damaged and/or missing siding, torn and/or missing screens on the pool enclosure, and holes on the exterior soffit near the front entryway remained on the property. The property has been in violation of the compliance order for 126 days of noncompliance from July 24th, 2024 to November 26th, 2024. I'm submitting 12 photos for the record. The pictures submitted for evidence are a true and accurate representation of the site at the time the pictures were taken. I'm also submitting an invoice for unpaid case cost in the amount of $29.85, plus additional case cost incurred in the amount of $65.79, for a total case cost incurred in the amount of $95.64.
Question? The pool enclosure that you indicated was in disrepair, does that present a hazard where a child could wander into the pool and become injured?
I'm sorry, state that again.
The pool enclosure that you indicated was in disrepair. Does that represent a hazard that a child could wander into the pool and become injured?
It's quite possible, but the screens being removed or torn does violate Chapter 26, Section 8.
No, I understand there's a violation, but I'm thinking more in terms of the screen could prevent a child. If that screen's not there, is there any other barrier that would prevent a child from being able to fall into the pool?
Without seeing the rear of the property, I can't tell.
And I don't see any photos of the screen enclosure.
That's right there. You're looking at it. Hang on, let me back up. That would be just the screen enclosure on the rear yard, and you can see that panels are clearly missing.
So it's an elevated panel that's missing, not a ground panel?
Not to my knowledge.
Right. Okay. So it's under where the brickwork is.
Correct.
Got it. Okay. It's not so.
Right, yeah.
Yeah. Okay. Okay.
Has there been any communication with the owner or any movement towards repair at all?
I have not had any contact with the property owner.
It says trustee in terms of the owner. I'm assuming this is the owners have passed away, and this is a trustee on part of the estate?
I'm not entirely sure.
It could be a revocable trust.
Isn't this the one, wasn't that car the one that had the California license plates?
Yeah.
Is that car still parked there, sir? Do you know?
Let me go to the picture from
I remember
yesterday.
this. We gave him 60 days because the car
Yeah,
was
it's
from
there.
California.
It is there, yes.
Yeah.
The car is still, there's a car in the parking lot in the driveway as of yesterday.
Is that the same car, though?
If it's a white Corvette convertible.
Well,
But
there it is.
That's not it's not the same car, though.
It may not.
But look at the
That's
the
in
other picture.
September, but if you see the picture from yesterday,
It still has
there's a
that top.
car. You don't have the license plate.
It's still
Oh,
got the
okay,
same
yeah, that is a
rag top.
convertible.
Rag top, yeah.
Yep, same car.
Same tan roof.
Yep, okay. So either the neighbor's using the driveway or...
I don't know if this question's been asked, has there been any repairs or any
Yeah,
obvious?
not to my knowledge. You can actually see it
Nothing
in
you can
this.
see.
You can actually see in this picture here that a couple of panels
Or less.
are there, and then there's actually,
Yeah.
well, it looks actually about the same.
These are not there on the
Right, so they've actually
current
had
picture.
more missing.
Or those aren't.
All right, is there any other questions or discussion? All right, I'll ask for a motion.
We already established a prima facie.
We did.
Well, this is
just
a
for
penalty.
penalty.
Got it.
Okay, I'll make a motion.
All right,
I make a motion to find the respondent is in violation of a compliance order in order to pay a fine amount of $12,600 be imposed, representing a fine of $100 a day for an additional 126 days of noncompliance from July 24th, 2024 to November 26th, 2024, plus applicable interest of 9.5% per annum. And said fine shall continue to run until respondent comes in compliance with the Punta Gorda Code. Is further ordered, respondent pay unpaid case costs in the amount of $29.85 plus an additional case cost of $65.79 for a total of $95.64 within 30 days of receipt of the order. And is further ordered, failure to comply with this order may cause the Code Enforcement Board to impose a fine of up to $250 per day plus applicable interest.
and why $100? The last one was 50.
Yeah, I picked 100 because there's no action being taken, and it would have been higher had I thought there was a safety violation where a child could get hurt in the pool. But they need to get attending to their property, and they're not responding to the city's requests, and they're not taking good care of their commitment to the city.
Is there a second? All right, there's been a motion and a second. Is there any further discussion? All in favor signify by saying aye.
Aye.
Any opposition? The motion carries. The board has found that the respondent is in violation of the compliance order and orders that a fine in the amount of $12,600 be imposed, representing a fine of $100 per day for an additional 126 days of noncompliance from July 24, 2024 to November 26, 2024, plus applicable interest of 9.50% per annum, and the said fine shall continue to run until respondent comes into compliance with the Punta Gorda Code, and it is further ordered that the respondent is required to pay unpaid case costs in the amount of $29.85, plus additional case costs incurred in the amount of $65.79, for a total of $95.64 within 30 days, did you say?
Yes.
30 days of the receipt of the order, and it is further ordered that failure to comply with the order may cause the Code Enforcement Board to impose a fine of up to $250 per day, plus applicable interest. Thank you. All right. Are there any other matters before the board? I think, Mr. Como, you wanted to discuss something?
I did, but I got a doctor's appointment, I gotta run.
All right, so we'll do that next time. Is there anything else on the agenda Staff comments. Mr. Price, you had a comment? Oh, never mind. I'm reading the minutes. Never mind. Is there anything else before we adjourn? All right, thank you. The meeting is adjourned. Mr. Price, thank you so much again for your service.
Thank you.
Don't be a stranger. You'll be around. And